So the next chapter, I mean, no big deal. Constitutional law. I mean, sure, we can do that in an hour, couldn't we? Easy enough to do. Look, we're just going to scratch the surface, but we will pull out and understand the key concepts that we need to in terms of business law purposes. Did anyone take my advice and look at the Constitution? You had a whole week to do it, 6, 7 nights. Nobody pulled out the Constitution. I'm always disappointed. Well, you can always do it tonight. So, Constitution of the United States, right? We talked a little bit about the legal system in Chapter 1, so this should sound pretty familiar already. So I'm not going to repeat the concepts that we've already talked about. We said that the Constitution imagines a system of federalism, which means basically a sharing of power between the federal government and each of the 50 states. It means that basically the powers that are given to the federal government really are delegated by the states to the federal government. Certain things have to be decided at a national level, but everything else is decided at the state level. And this is, again, that sort of the balancing of the powers. Powers not delegated to federal government are referred to as reserved powers, and those are for state governments. Powers given to the federal government are referred to as enumerated powers, right? This is sort of high school, American history. Is what we're talking about here. And how many branches under the Constitution? 3 branches of government. What are they? Legislative branches under Article 1. Remember, that is Congress, as dysfunctional as it happens to be these days, but that is Congress. Two houses of Congress, Senate and the House of Representatives. The executive branch is under Article 2. Remember, it's not just the president, it's the cabinet, it's the executive agencies, and so on. Vice president obviously is part of the executive branch as well. Article 3 is the judicial branch. That is the court system. The Supreme Court and the federal court system, the district courts, the courts of appeals, and so on, are part of the judicial branch, Article 3 of the Constitution. So what's built into the Constitution, which is really quite beautiful in a way, except that when it's so dysfunctional at times, it's checks and balances, right? Built into the Constitution to make sure that no one branch of government becomes too powerful. For example, the president can appoint a member to serve as a justice on the U.S. Supreme Court. However, the president needs 2/3 approval from the Senate. So it's, the 2 branches of government. Just one example of how checks and balances works out. What else is in the Constitution? The Supremacy Clause, which basically says that federal law, U.S. constitutional, federal law, federal treaties are the supreme law of the land, okay? State and local laws, we understand that states exist side by side, can do their own thing, but to the extent that they enact laws that conflict with valid federal law, those laws are going to be, listen to the word, preempted. And we use the word preempted quite a bit in the slides in the book and so on. Preempted meaning trumped by federal law. Okay? But look at the words, that conflict with. But if it's possible for the 2 of them to exist side by side, as we'll see numerous examples through the course of the topics that we're going to talk about, there's no problem, right? Because states do have the right to enact laws that the federal government does as well. So there it is, there's the word preempt. Preemption doctrine is a doctrine that basically says that under the Constitution, federal law will take precedence, will trump state or federal law. Congress may expressly provide that a federal statute exclusively regulates a particular area. So when the federal government enacts a law, they might retain federal exclusive jurisdiction, or they might say states can go above and beyond. Local governments can go above and beyond. And one example is environmental law. When we get to the chapter on environmental law, we'll see that there the federal government was very, very clear that, we're going to have minimum standards on clean air and clean water and blah, blah, blah. But you know what? You states run with it. You want to do more? Go ahead and do more, right? That's called concurrent powers. But for example, patent law, federal patent law, the law is very clear. It's exclusively federal law. It's not like New Jersey can just say, well, we'll extend that patent by another 20 years under state law. Can't do that. Exclusively federal law. And another sad case on Supremacy Clause. I hope I get, yeah, I think I have this one right. This was a pharmaceutical case that actually was an interesting fact pattern, made its way all the way up to the Supreme Court in 2013. And, you know, I'm tired of talking, give me a little break. Does the federal drug labeling law preempt a stricter state drug labeling law? Anyone, what happened in this case?
I guess the packaging on the generic, when somebody makes a drug and the patent runs out, everybody can make their version of it, but the labeling has to stay exactly the same.
Under the FDA.
Yes, and this, I guess, was it Vermont or
New Hampshire was one of those
New
states.
Hampshire state, they have a stricter law, but under the federal law you can't change it, and somebody took it and it caused a lot of damages to the person, so.
They sued.
Yeah.
Yeah, so I mean, that's exactly the facts of the case, and it is an interesting case because, yeah, I mean, this happens all the time. Pharmaceutical company, we're here in New Jersey, tons of pharmaceutical companies get patents for their drugs, and they profit off of that for the 20-year or whatever year patent that you have. The drug goes off patent. Lots of other companies start marketing it, generic versions, no problem. But here, the problem was the FDA approved the drug, and it had a bunch of different side effects, a bunch of different precautions. And when it went generic, I mean, there was a requirement that basically said that, you know, you cannot change that warning at all. And what they were contemplating was that, you know, you can't lessen it. They didn't really think to see that you could probably put more warnings. Well, the state of, I want to say Vermont or New Hampshire, it's one of them, had basically, they would have required even more disclosure. But, you know, none of the generic companies did that. And this woman, unfortunately, suffered grave injuries over something that perhaps, if the warning was there, may not have happened. Right? We don't know for sure, but may not have happened, and sued. And the question is, well, wait a minute. We always say that if the state law is stricter, then you abide by the state law, right? That's not a conflict. But the reason why the federal law here preempts or trumps the state law is because the federal law said that you can't change it. So it's not possible to comply with the federal and state law because they are in conflict with one another. You know, when we look at environmental law, it doesn't say that you can't change it. It says go ahead and change it for more. But here there was a quirk in that FDA regulation, and as such, as sad as this case was, there was no recovery. And that's an unfortunate thing, but again, if you're looking at the black letter of the law, Supremacy Clause of the Constitution, yes.
So what's the point of even having that state law then, if it's just going to defer?
Well, it applies in other cases, right? I mean, it would apply with non-patented drugs. You know, so just because there were more disclosure, it just didn't apply in this particular case. And I didn't look to see whether there's an effort at the federal level to actually change regulations to say that, you know, so I mean, you know, a lot of times sort of states go further or they test the limits, and they did. But I would be on the record as saying that it may not apply in this instance, but it could apply with disclosure. For example, it could apply to over-the-counter drugs, right? So yeah, it had more. All right, so if anyone had read the Constitution, I could have been talking to them about the Commerce Clause, which is just such a significant part of the Constitution. It doesn't say much, but it is just so fundamental to understanding federal versus state laws and federal versus state regulations. And what the Commerce Clause basically says is that Congress has the power to regulate commerce with foreign nations, well, that makes sense, among the several states, that means, you know, like crossing state lines, and with the Indian tribes. Now think back to when the Constitution was written. You know, we still had, you know, a significant Native American population. So, you know, so leaving aside Indian tribes, which, you know, obviously is not something as current, but look at the other stuff. power to regulate commerce with foreign nations. Well, I understand that. We don't want the state of Texas entering into a treaty as much as it would like to with Mexico. It needs to be done at the federal level. But what's really key here is among the several states. So when is it that Congress has the ability to enact laws because they affect different states, and when is it the states can have their own laws, right? But over the 200-300-year history of our country, where we've sort of been looking at the Commerce Clause, basically this is where the federal government gets to have a lot of power, in regulating a lot of different areas. Again, we're not going to get into the Native American part of it so much. We understand from a historical perspective that's really important. But it's really the foreign and interstate commerce, right? Commerce Clause allows the federal government the authority to regulate foreign commerce. So entering into treaties, trade treaties, and so on is exclusively something that the federal government does. But interstate commerce, meaning commerce that affects, between states, commerce that moves between the states, that is really particular. And I know this wasn't a case in the book, but I thought it was really interesting. This was the little text box that they had on a motel, I forget the name, in Atlanta, right? So think back to civil rights. Think back to, Congress passes a civil rights law that basically says you cannot deny people, Brown versus Board of Ed and the Civil Rights Act, accommodation, things like that. This, outline segregation. But picture it, it's still 1960s. We still have some southern states saying, what? And they're trying tooth and nail to keep their way of doing things. And there's a motel, and the motel says we are continuing not to serve people of color. And they're arguing that we can continue to do that regardless of the Civil Rights Act. And the reason they say that is because they say, well, look, this is, we're catering, we don't have multiple locations. We're right here in this, state of Georgia, and it's our business. And if state law doesn't prohibit it, why is the federal government telling us what to do? And they're really testing the reaches of the Commerce Clause. And the court comes back and says, whoa, wait a minute. You're engaged in commerce, and even in the 1960s, this is before the airlines, and yes, but this is before the internet and all of that, which would have put a quash on that right there. But the fact is that, there's commercial activities. You're going to have truckers from different states wanting to stay. And this involves movement of goods. I mean, you're in the hospitality industry. No, the Civil Rights Act does apply to you. You cannot say that you can refuse to do business with people based on their color or whatever the case may be. So again, it gives the federal government a lot of power in terms of under the guise of when we're regulating commerce, which is what the Commerce Clause says. Congress has the authority to do that, and it allows the federal government to have quite a bit of say. And if you wanted to be constitutional scholars, we would talk about things like the Dormant Commerce Clause, which basically means when something is dormant, it means it's asleep, right? So a situation where the federal government has power under the Commerce Clause, but it's chosen not to regulate that area, there the Constitution says it's okay for the states to enact their own laws, even if it means that there are 50 different laws in that particular area. And the reason is that even though the federal government has all this authority, the states have what is called policing power. And by police, I don't mean like policemen. It just means they have the power to allow their state and local governments to enact laws that reflect their view of public safety, moral, social welfare, and so on, and which is why we still have, commerce being regulated, like, for example, different speed limits in different states, right? You go, is it Montana? That barely even has a speed limit, it's like you can drive 90 miles an hour because why? Because there's no one living there. In large parts of the state, it's pretty vast, it's pretty open, it's pretty untouched. So yes, we're gonna allow states, you could have the federal government have minimum industry standards, but you could have states go above and beyond under their policing power, if you will, promoting safety and morals and welfare of their citizens. That's all well and fine. And again, we could go more into the Commerce Clause, but that's basically what we wanted to get out of that discussion. And obviously to say that the world has changed since the Atlanta motel decision, by the way. When we now talk about commerce, we're not just talking about truckers and moving goods along state lines. We're talking about business that I could be conducting standing at this podium, right? I could be transacting business through my website, and now obviously there is so much that the federal government can regulate in the area of electronic commerce. Why? Because the artificial boundaries of a state matter far less, right? And that's just the reality of 2015. Who knows what the reality will be in 20 years from now, 40 years from now. But we can see how, we just cannot sort of say that, well, we should be governed only by our state or local governments. It's just changing quite a bit. Things that come to mind are sort of the basic liberties that we think about: freedom of speech, freedom of religion, a right to a jury trial, all of those things, unreasonable search and seizure, on and on. So we'll be exploring, the criminal law parts of these protections in the criminal law chapter. We'll talk a little bit about the Bill of Rights, which of course are the first 10 amendments to the Constitution, and 17 others since then. And the point of these sort of amendments was to build into the Constitution certain fundamental rights and freedoms. To whom? Well, to natural people, to like individuals, but over time we've seen that a lot of this applies to, unnatural entities as well, meaning businesses, corporations, for example, also have protections from, for example, unreasonable search and seizure, right? You still need to get a warrant if you're going to search someone's premises, just like you need a warrant if you're going to look in the back of my car or something like that, right? And the purpose here is to protection from intrusive government, and government could be federal or state government, again, to kind of balance individual liberties against the power of a centralized government. And again, if I say Bill of Rights, most of us will think freedom of speech, right? That's so fundamental. The right to engage not just in oral speech, but also written speech, also symbolic portrayals, however you want to look at it, is protected by the First Amendment. And, over the history of sort of looking at First Amendment issues have been things like, well, is it absolute? Is there no restriction on speech? And you see, Supreme Court decisions sort of going different ways, not too many different, but the sort of underlying theme there is that, courts are going to try to bend over backwards to find protection of speech, and are really going to limit it in very, very necessary ways where it has to be. And we'll take a look at a number of cases that kind of bring it forth. But when you think about freedom of speech, think about it in 3 different categories. Speech that is fully protected, speech that has limited protection, and speech that might be unprotected. Okay? So let's talk about all of these. Fully protected speech is speech that cannot be regulated or prohibited by government. An example of that is political speech, right? This is a democracy, and it is our right as citizens or as corporations even to criticize our government. And it doesn't have to be just the president. It could be anything. It could be, even as some people might find quite offensive, burning a flag. And you might say, what's the harm in that? Well, it's highly symbolic, and it causes, a lot of emotional sort of upheaval. This is the sort of thing that's been tested in the Supreme Court, and the court says as distasteful as some may find it, it is protected under the political speech arena as being fully protected. And this is an interesting case. This was in the prior edition of the textbook as well. This is a case that is being brought by the state of California, or was being brought by the state of California, against video manufacturing companies. 2011, went all the way up to the Supreme Court, and the question was, yes, we have this federal law, First Amendment, Bill of Rights. Can a state kind of have its own law that restricts to some extent, not political speech, but violent video games? All right, What's the problem there? It sounds like, you know, as a parent, as some of you who might be or become parents, what's wrong with, you know, restricting video games? It's not outlawing them, but it's restricting them in some way in the marketing of them, or putting stuff, you know, on warnings or things like that. You know, this case goes all the way up to the Supreme Court, and the Supreme Court says no, no. And again, the reason comes down to, you know, where do you draw the line with First Amendment? Is this going to be a slippery slope where we're going to say, well, you know, certain books may be violent? You know, are we going to say that, you know, you can't read Lord of the Flies in high school anymore? I mean, what is somebody's definition of violence versus someone else's definition of violence? Yeah, I mean, can you have parental controls and things like that? One thing, but for a state to say that we're going to restrict violent video games, according to the Supreme Court, you know, tests the boundary of freedom of speech in a way that is unconstitutional. So, state law gets thrown out as violating federal law. All right, let's continue with speech. Okay, we talked about fully protected. Now let's talk about speech that gets limited protection. So here's the kind of speech that you can't prohibit, but you might be able to tell the speaker about how to say it or depict it or write it. Time, place, and manner restrictions. For example, offensive speech. Speech that is offensive to many members of society. I mean, define offensive, right? I may have one definition, you'll have another, and so on. So this is, again, difficult in some ways, and this sort of brings to mind things like cable television versus network television. And these days, I'm shocked by what's on network television at like 7:30 at night. But it just shows that our definition of what is offensive has been changing. Yeah, you can restrict time, place, and manner in terms of what you say in the interest of art or cinema or whatever that may be. Commercial speech. What can businesses use, for example, in advertising? And by the way, you know, you can move away from offensive speech and things like, you know, I was just driving in 78 and there are a bunch of billboard signs, right? And that's fine. Businesses are allowed to buy space, and these days a lot of them are digital. But there's often dispute over, you know, it's expensive to buy those billboard spaces, right? And if I'm going to buy it, I want to get as much on my business as possible. How small can I make the font on those things, right? I have freedom of speech, but someone's going to tell me, no, you know, your sign has to have a minimum of this lettering, and you can't use phrases like this, and blah, blah, blah. Why? Because public welfare is involved, right? I mean, what is the point of billboards? You want people to look at them. But if you make them small or coloring that could actually be distracting to someone who's driving at the same time, that is a problem. And that is a kind of speech that can be regulated in the sense that it could be restricted in how you say it. So yeah, commercial speech could be restricted, but you cannot prohibit it. So what is speech that is unprotected? Totally unprotected by the First Amendment and may be forbidden totally. You know, example might be, anyone? Obscene. You know, and you know, a lot of people say, well, what's the difference between obscenity and offensive? You know it when you see it, right? You know, pornographic, you know, like things that anyone would say, no way. You know, it's not offensive, it has crossed the line. You know, and we are absolutely not going to allow that in the public. Or, you know, the kind of speech, if you will, that could lead to violence. You know, this is the example of yelling fire in a crowded theater business, right? You know, that's not protected. Yes, you have the right to say whatever you want, but if it's going to lead to a stampede and people, you know, getting hurt, that's going to be unprotected, right? So that's fairly obvious in some ways, right? So let's take a look at a couple of cases. Again, you know, we talked about last class about the Supreme Court takes very few cases, but look at the kind of cases that we're talking about. We're talking about fundamental cases like testing, you know, Bill of Rights or other federal laws and so on. So this is a case, 2014, makes it all the way up to the Supreme Court, and it involves a Massachusetts law, right? We said the word statute is state law in this example. Does the Massachusetts statute violate the free speech of under the First Amendment? So for that, to answer that, you have to know what the facts of the case are. And the facts of the case here are an abortion clinic. And a state statute that says, you know, I mean, this is a divisive and big issue. I mean, it's in the news these days, right? The government may be shut down because of Planned Parenthood funding and all of that. So, yeah, these are all, look at it. We're talking about issues, deciding cases in 2014 and applying the Bill of Rights, the First Amendment, right? Think about how a living, you know, the document is a living document that can be applied to issues that we face as a society today. So the law here in Massachusetts was abortion is a divisive issue. There are people that want to picket and talk to people that are going into abortion clinics to try to talk them out of it, okay? And so Massachusetts enacted a law that basically said that if the abortion clinic is here within a certain area, like a block or whatever, the sidewalk, the entrance, you cannot have those protesters. And the reason is that it's hard enough for someone who's going to have to go through this to have this kind of don't do it or you're a killer or whatever, you know, and that's a state law. The question is it a violation of free speech? You know, you can't do it 35 feet, but you can do it 36 feet. You know, aren't we giving individuals free speech and still protecting, you know, the individuals that use that claim? What does the Supreme Court say? Is it a violation for Massachusetts to enact that law? And they say, yes, it is. You know, again, you know, if you're going to have free speech, you're going to have free speech. And you cannot stop people, even if they want to come up to you. I mean, again, assuming that no one's getting hurt, no one's touching, you know, it's not assault, none of that. If all someone wants to do is, you shouldn't do this, you shouldn't do this, and they're going to do this up until you get to the doorstep, the Supreme Court says that is free speech. Cannot have it. And that is a case that is 1 year old. So again, very, very interesting. And the other one is also a fairly recent case, which a lot of people thought was so distasteful. Couldn't you figure out a way to not have this happen? So this is the case where you have a funeral. And there is a vocal church that basically believes that the reason that the United States is suffering and all of that, and you know, is because gays in the military. You know, those kinds of policies are what is breaking down our society, blah, 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 and they're protesting. And the thing is, how close can they be to a funeral of someone who's burying their, you know, their loved one that just died in you know, defending their country? And most of us would say, that is crossing the line, that is too much. I mean, at least give the family the time to grieve. You know, you shouldn't have people chanting things like, you know, your son or daughter deserve to die because they blah, 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 you know. And the court says, again, really difficult decision. We have to take emotions out of it, and we have to say that the First Amendment does protect individuals from picketing wherever they want to. And you cannot have restrictions on free speech, period. So, again, recent cases that really flesh out just how, you know, how sort of expanded a right of free speech a democratic society holds it to be. And here we go, another one, freedom of religion. Again, you know, this is sort of the basic liberties. And when we talk about freedom of religion, we're talking about two different clauses of the Constitution. Because the first clause says, the Establishment Clause says, look, the government may not either establish a religion or promote one religion over another, that we are a secular nation, okay? On the one hand, we have that in the Constitution. And on the other hand, we have the Free Exercise Clause that basically says the government may not interfere with the practice of exercising that religion. Any religion, right? So free exercise and at the same time Establishment Clause. And these get litigated quite a bit. And one case that was litigated, I'm sorry the date isn't there, but this is last year. The Burwell versus Hobby Lobby case. Everyone knows Hobby Lobby? Anyone not know Hobby Lobby? Hobby Lobby are like stores that sell merchandise, all kinds of merchandise. You know, I mean, I've never been to one, but I'm told that it is like a Target? Is it, I mean, they sell everything. Crafts, whatever.
AC more.
Thank you. Okay, that kind of a store. So, you know, I mean, it's a store. We can go and shop there. The thing is, Hobby Lobby is a privately owned and it has owners that subscribe to a fairly conservative practice of Christianity. Okay? So the issue that went up to the Supreme Court was, under the new health care law, every insurance, if you sponsor a health plan, like employers give their employees health plan, under every health plan, women are entitled to contraception at no cost. Okay? That's the law. Everyone has, you offer a group. The problem was with the owners of this company was they did not want to cover contraception. And they said, so there's a religious exemption. So for example, if this was a church, if this was a synagogue, if this was a mosque, they would get an automatic exemption because they're a religious organization. The question that was being tested at the Supreme Court level was, how expansive is the free exercise clause, and does it apply not to a church or religious organization or even a religious university, but a private for-profit corporation? And a lot of people were shocked by the decision because it was a 5-4 decision, so it was fairly divisive, where the court said, we're going to allow this business to uphold their religious conscience. And and this is going to be sort of interesting to see how this goes. And since then, the government has issued regulations and basically said, well, in this case, it's not like Walmart or Costco or Pfizer or any of the big companies can do it, but there's something unique about Hobby Lobby because it is a privately owned business. It is a very small group of owners, and although it employs thousands of employees around the country, in that kind of a business, religious conscience rules the day. And since then, the government has come up with ways of accommodating employers like this where they don't have to pay for it or whatever. But the fact is that, the notion of protecting not just religious organizations, but even for-profit corporations, that is a real expansion of the free exercise law. So that was a very interesting case. And again, we can go on and on, but let's talk now next about equal protection clause of the Constitution. So, under equal protection, the 14th Amendment, a clause that provides that a state cannot deny to any person within its jurisdiction the equal protection of laws. Simple, right? Which means that you can't classify and treat similarly situated people differently. And by the way, it's not just people as in you and I, artificial people like corporations and businesses are also protected. And you cannot make classification of individuals unlawful. Okay. So, to really understand equal protection clause, we would spend, more than the time that we have. We would spend a few class sessions understanding all the laws, but here we're going to go through it fairly quickly and boil it down to, well, if a case comes before the Supreme Court, and they almost always go before the Supreme Court if the case rises to this kind of an issue, what is the court going to do? All the court has to go by is what the Constitution says, which says a state, by the way, it doesn't just mean a state, even the federal government, the government cannot deny to any person equal protection of the law. That's all it says. How do you apply that? Well, the Supreme Court has come up with a few different ways. They're going to say, we're going to look at each of these cases depending on what the classification is. So if the classification is suspect on its face, like race, or fundamental rights, like voting, we're going to apply the strict scrutiny test, meaning that basically that's going to be a huge no. Right? Under the strict scrutiny test, you really, how could you possibly justify classification based on race, right? But we saw last class, voting rights, voting was a fundamental thing, but the Supreme Court did say that, certain states no longer have to go and get their changes under the Voting Rights Act be examined by the government, the federal government anymore, because we think that there's equality. We don't think voting is a problem anymore. But they're really going to apply the strict scrutiny test because when it comes to race, when it comes to fundamental rights, there really ought not to be differences in today's day and age. So that's the strict scrutiny test. But But they said we're going to apply sort of this in-between intermediate scrutiny test when it comes to other kinds of classifications. For example, gender. And you might say to yourself, what? You could have, differences? And the court says, no, generally not. But imagine a case such as certain branches of the military, like Navy SEALs or something like that. Yes, women serve in the military and serve, proudly and what. But there are certain things that we recognize that just wouldn't be possible. And so we're going to say that we're going to apply that even, in today's day and age, there might be some differences based on gender. Some, very few. And for other classifications, even though it says equal protection under the law, it might be that there is a rational basis for certain classifications, and the court will uphold differences between people, even though we say that there can't be differences between people. For example, we'll talk a lot about, when we get into employment law, about laws based on discrimination. So there is, under the law, federal law, something called the age discrimination, right? So under that law, only individuals over the age of 40 are protected. So, yes, you have, equal opportunity in employment, but we're going to have a special discrimination law that only protects people over the age of 40. And you may say, why 40? Isn't that discriminatory? Doesn't the law says, well, look, rational basis. And it is kind of rational to apply an arbitrary age, because we know that companies can save a lot of money and they can start discharging people and commit age discrimination, and it is a valid societal and business purpose to protect an age group that, we just call them, it's hard to imagine a 41-year-old as a senior, but we have to come up with some arbitrary thing. And there are other things. For example, you could work in any industry, but if you decide to go into farming, you get a subsidy. And you might say, well, why are farmers so special? Why is it that what I do doesn't get a subsidy or a tax break? Well, why do farmers get it? And the law says, well, rational basis. Rational basis is, if they didn't, we would be, farming doesn't pay well. We want to entice people to do this so that we're not dependent on foreign economies, that we do have enough homegrown agriculture, and so on and so forth. So yes, there is equal protection, but there may be reasons, rational basis. And again, we're not talking about, here we're talking about more business-related decisions as to why, certain classifications might be okay. All right, I'm going to run through the cases in this chapter because there are just so many. The next case was also a huge case 2 years ago, the United States versus Windsor, Supreme Court case that basically struck down. Everyone know what DOMA is? Anyone know what DOMA is? From reading what DOMA is, right? Defense of Marriage Act. So back in the 90s, a law was enacted and passed by Congress that basically said that although the country would be respectful to same-sex couples, they would not recognize a same-sex marriage, even though states may say that that's okay, when it came to federal benefits, like Social Security. Like, for example, if a spouse dies, the other spouse is able to get survivor benefits, right? But if your marriage is legal, for example, now this has even changed because same-sex marriages are now legal, but this was 2013. If your marriage was legal in Massachusetts, but you happen to be married to someone of the same gender, you couldn't get federal survivor benefits and so on. So the court in 2013 basically said that part of the Defense of Marriage Act is unconstitutional. Why equal protection? And they went to looking at it under, the stricter test and basically said that is discriminatory. That is not equal protection under law. So again, these are current issues where we're applying the Constitution and the Equal Protection Clause, and it is absolutely fascinating. All right. The last case was actually a case that, I want to say it was last year or the year before, that we actually, I'm going to give out assignments and I'm going to assign topics, was a case that we had a class assignment on. This was a Michigan case that went all the way up to the Supreme Court. And when the students presented, the case hadn't been decided, so it was really interesting. And I thought it was such a good case to cover on a college campus, because the case was about affirmative action and whether or not you could have a slight preference in admission given race. Okay? So basically, what happened in this case was Michigan enacted a state law that said that in state universities, there will be no more preference given to based on race. And this was challenged, and the question was, does this amendment to the Michigan Constitution that eliminates race-based preferences in college admissions violate the Equal Protection Clause? And the court said no. 5-4 decision again, basically saying that if the citizens of the state have decided that they no longer want to have this policy, that's okay. And that's sort of setting the stage for a lot of affirmative action in education around the country. Now, if the state still wants to have it, that's fine, but it is not unconstitutional for a state that has passed an amendment to their state constitution to say that they no longer want to have race-based preferences based on education. So fascinating stuff that is being played out today, and there will be other cases. In fact, I'll try to find one or two that will be relevant for our discussion when we do our assignments this semester. Questions so far? I know I'm sort of zipping through this material. Okay, let's next talk about due process. So under the Constitution, the other thing that we expect is that we as citizens, whether we are individuals or corporations or businesses, we will not be deprived of life, liberty, or property without due process of the law. Where does this come from? It comes under the 5th Amendment of the Constitution, applied to federal government. 14th Amendment now applies to state and local government. Your takeaway is it applies to all government. Government cannot deprive someone of life, liberty, or property without due process. And so what that means is, in order to do that, you have to follow due process. Well, what is due process? Due process is two things. This is just terminology, that's just part of the course, substantive due process and procedural due process. So what do we mean by that? Substantive due process basically says if the government is going to pass a law, that law has to be clear on its face, and it can't be overboard. So, would a reasonable person understand what the law is? Because otherwise, the law could be void. So, if you're going to say, abide by the law, or we can put you in jail or fine you, well, substantive due process says I have to understand the law in order to abide by it. So, I don't know if there was an example in the book, but the example I would give is, what if a city passed an ordinance that said that people of each gender shall only wear clothes for each gender, meant for each gender. So if you're a guy, you're supposed to wear clothes that are meant for men, and if you're a woman, do you understand that law? For one thing, you may be violating it with a shirt that looks a little pinkish to me. No offense, I'm just saying. Have you just violated the law? And you might say, wait a minute, it's got the Nike thing going on. It's a t-shirt. Look, that is vague. I can't possibly, it's not clear. I don't understand what it means to wear one gender clothing versus another. I may be violating it. Perhaps I should be in a skirt. I don't understand what that means, right? So, that's just ridiculous. And, I'm giving you a far-out crazy example, but, it may be that a law is vague. It's incomprehensible. It's too broad. It is, usually when corporations challenges, it's contradictory. It doesn't make sense. That would not be due process. But when we think about due process, what we normally think about is procedural due process. Because oftentimes the law has been tested, and it's usually going to be, clear and, understandable by the average person. Requires the government to give a person proper notice, proper hearing of legal action before any of their fundamental rights can be taken away. Right? That's what we think about when we think about due process. And that's things like, well, you know, if someone's going to, say that I'll give you a business example, my license to broadcast over the airwaves is going to be revoked because I put on material that was inappropriate under section blah, blah, blah of the FCC. Well, they can't just do that. You know, I have to be, I have to be providing notice. I have to be able to defend myself. I mean, the crazy instance from the Super Bowl from, 10, 15 years ago. Remember when the Super Bowl was on CBS and there was the whole Justin Timberlake, Janet Jackson nonsense that happened. Well, you can't just revoke, an FCC, I mean, it's a big deal. CBS has to have the right to defend itself and say that was a wardrobe malfunction and nothing more, or whatever the case. You have to give the ability to the party that is affected to defend themselves, to go through the process before their liberties can be revoked. In this case, all it is revoking someone's, license to broadcast a certain thing. So that's what we mean by procedural due process, and we'll talk a lot about this, but I just want people to understand terminology. All right, have you had enough of the Constitution? Because the last thing we're going to cover is privileges and immunities. And this is another clause in the Constitution that says, it's an interesting one, citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Okay, what does that mean? What it means is that, everyone has a right to privileges that are granted to citizens of other states. So what that means is no state shall make or enforce any law that abridge or somehow restrict the privileges and immunities of citizens. The notion being, I'm not just a New Jersey resident, I'm a citizen of the United States. So for example, if I see a condo in Florida that I want to buy, I should be able to buy it. Just because I'm not a Florida resident should not, Florida can't pass a law that says no other people from any other state can buy property. I think that would just be ridiculous. That would violate the Privileges and Immunities Clause. So same thing, the clause prohibits states from enacting laws that what? Unduly discriminate in favor of their own residents. It only applies to citizens, it doesn't apply to corporations. By aliens, we mean foreign nationals. We don't mean people from Mars. I always sort of end this with, everyone here at Rutgers a New Jersey resident? Is anyone not a New Jersey resident? No one? Once one? So, you know why, perhaps? Out-of-state tuition. And wait a minute. Did we just say that you can't have states enacting laws that favor their own citizens? So why is it that someone from New York, Pennsylvania would have to pay more? Isn't that a violation? That's been tested, and the courts have said that is not undue discrimination. Why? Because every state can do that, and you can, it's not unduly favoring your own citizen. That's okay. So,